and welcome to today's webinar. I'm James Vann, and Jim Beck and I are here together as part of Vann Attorneys to lead in a discussion today about litigation and being prepared for litigation. So again, we're thankful that you are participating. If you have questions, you may submit them one of two ways. You either click on the go to webinar control panel on your screen and enter it there, or you can send it to us by email at webinar@vanattorneys.com. So again, hopefully that makes sense to most of y'all. It probably does. So we're going to talk about today prepping for litigation and how do you best be prepared. Some of the topics that we're going to talk about are identifying the potential issues, documents that are needed in that, what electronic records might include. Communication is always the key. What people are needed or will be necessary, and then we'll look at the evaluation of the claim and then sort of also a strategy. That gives you a little bit of an idea of what we're going to be looking at. And Jim and I have thankfully been doing this for a fairly long time. We're not an expert, but we got a lot of experience in it. So hopefully that will help in the conversation. So again, looking at the issues, how do you start off? What are the issues and that you're looking at? Well, obviously your company or your business would be part of it, and then who else is involved? What other companies or what individuals are involved in the transaction? And for the most part, the people that are involved in this webinar today are business owners or business representatives. So again, what companies might be involved? Certainly, if it's a contract, it's probably the company that you had a contract with. Could it be another vendor that's party, or a transport company maybe? I'm trying to think of some that we've had recently.
Well, you could have construction issues, so it could be a party you're not even directly contracting with. It could be an individual that got injured on your premises, or as a result of one of your employees' actions while on the job. So there's a bunch of different potential parties and claims that could be out there. And so most of the issues that come up around here are generally business disputes, but you never know what else could be out there.
Yeah. Could be a surety company or potentially possibly an insurance company. And again, it could be, sometimes you may think, this is not a direct issue with my customer. I don't want to sue my customer. But if it's a construction issue, and especially if it's a payment, sometimes you may have to. You may not have a choice. But that sort of helps you identify what the issues are. And again, sometimes you want to really look at that in a broad perspective so that you can hopefully include every possibility of recovery that you could. And again, you may wind up narrowing that down as you go. But instead of starting narrow, you want to try to have that as wide as you could.
I think one thing, though, to think about is a lot of times you think of litigation when someone sends you a letter and says, "Oh, we're going to sue you if you don't do this or that." But sometimes there's a potential claim before the other side does, and so if that's the situation, you've also got almost a better opportunity to get prepared for what's coming.
Yeah.
So don't just think of litigation preparation once you are told there's an issue, but also if you have, something out there that you think might come up.
Someone had submitted a question ahead of time and said, what are some of the typical reasons people end up in litigation? And generally, it's a dispute. We represent mostly businesses or individuals that are related to a business. And a lot of those it seems like a lot of it's you're chasing money or money issues. And sometimes it's, you want a specific performance, or it could be an employment related claim where, there's a non-compete and the person who left is violating that non-compete. So it could be a whole host of things, but it's non-payment, damage to property, dispute among business owners could be if business owners are seeing an issue two or three different ways and can't get beyond that. So there's a whole host of those types of reasons. So we've got a poll question that we're going to pop up for you based on just sort of get a little bit of a feedback from you regarding the company. So the question is, the company I work for prepares with policies and procedures in case we enter into litigation with customers and their business. So if you will select one of those. So do you feel like your company does a good job of preparing you with policies and procedures? Yes, no, sometimes or never. So if you will vote there, and then y'all are doing an awesome job of voting. We are almost at almost 70%. So one or two of y'all got to hit the button and you'll be done. Be close to it. So we're getting there. So we're going to go ahead and close that out, and then we will show you the results of
Are we
that.
sending those responses to their company?
Yes, we will. No, we will not. Those are secret. We can't even see behind the curtain. So we have no idea. So, all right, you can see this, hopefully, the results of that. The company I work for prepares with policies, yes, 20%, no, 20%, sometimes 60%, and never 0. Thanks, that's good. So that's an interesting breakup there. So
sure.
Hopefully that helps y'all as well.
All right, I'm going to talk a little bit about documents and what to consider and think about when there's a potential litigation issue out there. So what you should be doing immediately when you find out that there's either an issue that might arise or one that already has, and you're starting to sit down and figure out what you need to be doing. There are documents that are relevant to that particular issue, whether it be a contract, when the issue somehow arises out of a contract. If it's a collections matter, there's going to be some kind of contract or agreement. If it's a business dispute, there's going to be some kind of contract, or even in construction, there's likely a contract. What correspondence already exists out there, and that's important because when you get into a lawsuit, or even before the lawsuit, you want to be able to look back and say, well, here's how this thing evolved and turned into an issue. Here's what we talked about. Here's what the contract ended up being. And here's how the relationship between our business and the other party sort of transpired over time. And correspondence is a lot of times one of the most important aspects of your documents to establish your case.
And a lot of those now are emails for the most part. I mean, I bet 85% of that, if not more, is an email. So the thing that we've encountered with a lot of our clients, and they range from small mom and pops to privately held companies, is what kind of an IT backup do you have? Are your emails on your individual computer, or are they saved to a server somewhere? And is there a company policy that keeps that, and then for how long? And sometimes it's really, I'll take that back. A lot of times it's really important to keep that. We have a case now that we are struggling putting our case together just because we're limited with the amount of correspondence from our end, and we're putting the pieces together from everybody else's perspective, and that's not fun. I've met with a client this week in a different situation, and they've got several people on the IT staff. They're bigger, and man, it's night and day different. So again, you don't have to be huge, and thankfully the cost today is a lot more manageable than it was 5 years ago, to be able to host emails from everybody in your company on a server. So and then have somebody be able to go pull those out without having to look at each and every email. You do it from a systematic standpoint. So that's a huge piece now.
Yeah, and like you said, most everything's electronic. You're not really getting letters, so to speak, until stuff goes haywire anyway, when lawyers start writing. Other important documents are any kind of notes that you have within your either job file or anyone involved in the whatever it is, if it's a construction job or if it's a collection agent or some kind, any kind of notes that might be in the file, any kind of reports, invoices, work orders, all of those things are important to maintain and keep in some organized form so that when you need that stuff, you can refer to it, you can grab it and get it very easily. Some things to think about are what documents determine the relationship of the parties, and by parties we mean you and the party involved in the dispute. So if it's your client, your customer, your employee, there's obviously documents there. If it's some third party that isn't directly in a business relationship with you, then maybe there's a whole lot less documents and you got to look somewhere else. But it's just important to think about what documents are important. And frankly, when you get a potential litigation issue that comes up, go ahead and look back at those documents and keep that stuff fresh in your mind as you go along. One thing that we really want you to focus on is putting important documents in a place where they're going to be saved and kept for a period of time. And if a litigation problem comes up, you need to make sure you preserve those documents, because if you don't, then the court can hit you with some negative presumptions about what those documents said. So it's important that you maintain documents related to any dispute or potential dispute. And so, for example, if you've got let's just say it's easy to talk about construction. So you got a construction project, the job closes, you don't know of any disputes yet. Well, you're going to want to maintain that stuff for a little bit of time in case something down the road pops up, and you'll have access to all the information.
I was in a deposition a couple of weeks ago that the opposing party was leading, and one of the questions they ask is, obviously the people in this, the companies in this litigation knew that an issue had arisen, and either though they hadn't started shooting at each other, they weren't happy with each other. The opposing counsel asked this guy, the person who was being deposed, has your company done anything to protect the documents that they had when they knew that issue was rising? He's like, no, we didn't. And that was an honest answer, it seems like. But number two, I'm not sure that was the best answer that his company should have come up with. His company should have said, oh, we smell something. We better make sure we're preserving the documents here.
Well, maybe it's a good idea to have a policy about what you do with emails, what you do with invoices, all that sort of thing. We talked briefly, James did a little bit about electronic records, but let's go into a little bit more detail. And really, electronic records are documents. It's just a kind of unique aspect of it, because you've got such a variety of types of documents in different locations and different people's possession. For example, your employee smartphones, they could have pictures, they could have emails that you don't have on your company's servers. There could be a bunch of text messages between any of your employees and the opposing party. That could be, just any number of things. And the main thing here is to have a policy or procedure for making sure that information gets into the company's hands, gets maintained, gets saved, and you can access it, and when necessary, you can produce it to the other side. And even for your own company's benefit, you can review what is in there, because a lot of times that information is going to help you in proving, whatever your case is. And as we said, pretty much everything is done electronically now, and it's not something you can avoid. You've got to address it. You need to address it before stuff starts going the wrong way.
And you really can't, in today's environment, because everything is heading that way to electronics, you can't say, yeah, we just don't have it, without doing a diligent search of finding it, looking for it, and trying to figure out what that, whether or not you actually do have it. I mean, I know people have said, yeah, we just don't have it. I don't think they really looked. 10 years ago, that answer was acceptable. In today's market, I don't think it is. I think that's going to kick up some ears.
Yeah, and I think people think, oh yeah, emails. Well, I've got all that, but people don't think, oh, text messages. Well, text messages can be the primary manner of communicating on a job site or between an employee and a boss. I mean, who knows?
Yeah.
So those are things that are important, and it's also, you need to have a way to get access to and maintain those records.
We just got a question that came in that says, do we have to maintain electronic records such as emails for past employees? And I think the answer to that is yes, because they're representing the company. But so yeah, you do. You need to preserve those, in however your company does it.
Yeah, I think that would be accurate to, with respect to their company emails.
Right.
Not necessarily they've accessed their personal email on your server, but you've got to at least have their company emails and save them for whatever period of time you're saving, your current employees' emails. And whether it's 5 years or 10 years, there needs to be a policy so that you can point to that policy and say, we're trying to comply with all of our requirements. We've saved these emails. We've deleted, even if you've deleted that employee from your system, there needs to be a way for you to save whatever was in that email account.
Right. And then, a lot of times we've helped companies develop electronic record policies. So if your company doesn't have one, let us know so we can try to help you with that. But regardless, if y'all don't have one, if your company doesn't have one, we really would encourage you to set up a policy, and it will include a lot of different portions or parts of the company. If there is an IT department, but it's going to include finance and pretty much everybody. So just something else to think about. So communication. Obviously, we all know that is the key. And if actually you look at the picture, this old geezer is on a cell phone. So even he has joined the portions of technology. So what do you need to do as far as communication? Well, what discussions need to occur when a potential issue arises? What conversations are there? Who's included? And by the way, y'all are going to hear a bunch of sirens in just a few minutes, so we apologize.
There goes the fire truck.
Yeah. Okay, they passed by. What discussions need to occur when a potential issue arises? It really depends on what the issues are. If there are other departments, if it's sales, if it's warranties, a warranty issue, is it the credit department because of non-payment? Is it a liability issue? Is it HR? It really depends on. So the thing you need to really ask is who has information about this for our business that can be helpful. A meeting I was in not too long ago with a client, we were putting together their case, and realized that they had to include their IT people because we knew we were having to go back and look for documents stored on the servers. It was credit issues, it was delivery ticket issues, and even third-party transport companies that transported the equipment and materials from one site to another. So again, you really need to go back and say, okay, who all needs to be there? Who needs to be included? Who do I need to ask those questions? Could it be the owner of the business? Could be, if they're involved in the business or in this transaction. And then maybe who on the outside knows information about this. Could be the opposing parties, obviously. Could be other groups, vendors maybe. So that sort of hopefully helps hit the issues of who needs to be involved, and then who do we need to have conversations with. And then the documentation of meetings. Again, saving the documents. Hopefully you've got a place to save those in a systematic way because it makes it easier for you.
Well, I think that's important too because you're having these discussions very close to the event causing the potential issue, or once you've discovered the potential issue. And the earlier you start documenting, the better not only your memory is going to be of whatever is going on, but the more reliable the discussions are. Because 2 years from now, you have your first conversation about it, but you have no records of anything. It's going to be really hard to remember, well, what did we talk about when we were arguing over the delivery of whatever it was, or that sort of thing. So the sooner you can do this and keep a record of it, the better your case will be.
Mm-hmm. That's a good point. And just be diligent. And I think most of the time saving documents and saving emails and communication helps your case for the most part. I know obviously if you're on the other side and if they're trying to cover stuff up, maybe they don't want to save the communication, but electronically it's there, and it's easy to save today it's easier today than it was probably earlier. So let's talk about the people. So who are the potential witnesses? So, who needs to be in that conversation? That could be inside or outside of your organization. Again, the question is who has knowledge about this? Not hearsay knowledge necessarily, but about personal knowledge about whatever that issue is.
Yeah, so if it's an injury or something, who was there? If it's a dispute over the something that was produced or delivered, who was involved in that delivery, who was involved in ordering the product. And it's good to figure these things out right away, as we've been discussing, because you're dealing with people whose memories come and go and vary.
Yeah.
The sooner you can figure out who knows something and talk to those people, possibly the more accurate your side of the story is going to be.
Yeah. And then just sort of asking that opening question, who's in the know of this? And I'll tell you something else, something to really think about. People leave companies all the time and go to another company, or they may retire, or they may move. If you know that there's an issue that's boiling and someone on your team is going to retire, or they're moving, or they're relocating to a different job, go ahead and do everything you can to document from them everything they know about, or the documents that they may have about that issue. Just because I tell you, it seems like almost every case we have, such and such was part of this, but they're no longer with our company. They moved, retired, or sometimes they die, unfortunately. But so you just need to document as best you can early.
Yeah, and that also goes back to our earlier discussion on documents. If you've got good records, emails, invoices, and work orders, and all that sort of stuff, it's a lot easier to glean what was going on at the time if whatever people were involved are unavailable, can't find them. So again, it all kind of goes back to documentation.
We got a question earlier that was one of the questions was, do clients sometimes, even though they're innocent, either 100% right, do they still typically settle in order to get things resolved, get it over with? And I really think that's a great question to ask. I mean, sometimes that answer is yes, sometimes it's no. We had a client a year and a half, 2 years ago, I think. We did a trial for, and I kept encouraging him to settle this thing beforehand. It was a crazy, stupid issue. He was in the right, almost 100%. I'd say 95% in the right. And they just had another crazy defendant on the other side, and they wouldn't let go. But he could have settled it for substantially less than what he paid us, but he didn't want to do that. And he had, thankfully, offered a lot of opportunities to settle, but didn't. So, should you? Economically, we'd say, yeah. We try to look at it economically. Sometimes people say, I'm going after because this is the principal. Okay. if you tell us that, we're going to remind you of it just so that it doesn't come back to bite you or us. If you want to make a principal issue out of it, that's okay. Sometimes you have to do that in business. But that, not every company does that, and some companies, I know they do because they tell us we're in the right. We're going to make a point of this so that it's known in the industry that we're not going to be ramrodded for that. So,
and I think that's why you want to evaluate the claim for, as James was just talking about, cost, outcomes, because I think we can add one there, and I think the word on the bottom can say principal. And if that's what it is, that's what it is, and sometimes, okay. But when you're talking about settling, when you're talking about what proactive actions to take, when you're talking about do we move forward with a lawsuit, do we make some sort of proposal to make this go away before it happens, those are the things you think about. You think about the cost. Litigation's expensive. Well, okay, what's the forum? Is it going to be in court in the town, or the county where you're located? Is it going to be in New York City? Is it going to be an arbitration? All those things matter, not only to cost, but also to potential outcomes and how you need to look at the case going forward.
Yeah.
Also, what's the risk? Are you right in this case, or is it 50-50? Is there no way to tell until you litigate it?
Probably not where you want to be.
It's exactly. And so you can't weigh just one of these unless that one thing is principal, and you don't care.
Yeah. Because
there are people that's how they feel. But most of the time, you're looking at all these different aspects of the claim. Does it have any validity? Is it a situation where your loss could be so significant that you need to find a way out of it, or that you could spend $20,000 to get 10, or maybe it's one where you spend 5 to get 30. I mean, it's all goes into the analysis here. But being proactive early on, figuring out what the issues are, who the people are, what they know, all that is going to help you determine whether you've got a strong case before it even starts.
Yeah. All right. So we're going to go over to our second survey question, and it has to do with what creates stress for you. So hopefully you see that on your screen. So the question is, the following items create the most stress for me when the company or my company enters into litigation. So mark all that apply. So it's gathering supportive documentation, meeting with the attorneys, preparing to be deposed, which is lots of fun, the mediation and negotiation, or attending a hearing in court. So we are, percentage-wise, y'all are voting, doing a good job. Keep hitting the buttons that apply to you. And we'll give you about another 5 or 6 seconds. So we obviously know that there's some stress involved. All right, so let's close that out, and then we'll show you the. So gathering supporting documents is number 1. Number 2 is preparing to be deposed, and then or attending a hearing in court. Yeah, and then mediation negotiation. That makes sense. That's interesting. So that's good. Thank y'all for voting. I hope that helps you and your process. And I can tell you, we really, really, really try hard to eliminate stress for y'all, for our clients. But we know some of that just exists. But you know what we love being prepared ahead of time, and that a lot of times takes away the stress. And so one of the other questions we got today is having to do with what causes the litigation. Is it because they haven't paid attention to the case, and to the situation, to the transaction? Because most of them, I would say no, because a lot of times I would bet you 75% of the times, our cases, our clients did not know ahead of time that this was going to happen. Everything seemed to be fine until one moment, and that's when it sort of flipped. It's not generally the clients don't generally see the litigation coming or the litigation issue coming. It's generally, I think, most part, it seems like it sort of happens.
Yeah, I would agree with that. When our client's the one getting sued or getting a demand, it's because some unforeseen event occurred, and things just happen. And then when it's the other way around, it's usually, it's usually that way. Sometimes you can foresee a potential collection issue. You can foresee an issue when, a project didn't go the way it should have. But I think for the most part, it's not a matter of our client not paying attention to something.
Yeah.
It's usually just one of those things, which is why basically in pretty much every dealing you're involved with, you want to just have in the back of your mind, you never know. Keep the documentation. Make sure you've done your due diligence.
So let's look at the strategy just a little bit. What does success look like in potential litigation? Are you trying to get the money? Are you trying to get some kind of an order, restraining order maybe, or are you trying to minimize loss? And so a lot of times we will ask, what does success look like, or what's your goal? What do you want to get out of this? What's your ultimate? A lot of times if it's just I say just a money owed on account. I mean, obviously everybody's goal is to get as much money in as quickly as you can. But if there's like a real knockdown, drag out issue, we ask those kind of questions. What are you looking for? And hopefully you're thinking about that as well. What does success look like? So it sort of guides or hopefully sets the roadmap as to how you want to proceed with that.
And you can be even specific with that.
Yeah.
So let's just say it's a collection issue. Well, they owe you $400,000, but they're out of business, and the personal guarantor is looking for work. So maybe success in that case is, get it off your books. I mean,
right.
So it really is going to be case specific.
Yeah.
Just depends on the situation.
Yeah. And then, how do you minimize your loss or maximize your recovery? What do you need to do? And a lot of times we will meet, especially if there are major cases. When I say major cases, it's one of those that is abnormal in the course of a business. We'll sit down and sort of map it out as to how we think it's going to go. And again, of course, it can take different routes at any place, but a lot of times you can sort of map it out at least 60, 90, 120 days out, figure out how you think this case is going to go. And a lot of times that's helpful. So you need to know that. And if you ever have questions, we're helping you on something, and you don't have a clue, let us know, because we'd love to share that with you so that that hopefully reduces your stress and again maximizes your overall recovery. And again, just sort of having a plan how you work through that. Being prepared, we love being prepared ahead of time because it makes your life and ours and everybody else's a lot easier. It just really goes much better. We really hope this is helpful for y'all. If you have questions, please feel free to reach out to us. You can email, call us. Seem like we're almost here. Always. We go home. We do go home. Thankfully, that's family and dogs. But let us know. We'd love to help you. If you have not connected with us on our website or LinkedIn or Twitter, that kind of stuff, we'd love for you to. I'm not much on Instagram, but we have an Instagram page and a Facebook page, so I'd love to do that. Just for information purposes, our next webinar will be on May 23rd at 3 o'clock. So mark your calendar, May 23 at 3 o'clock. Hope you all have an awesome day, and thank you so much for participating.
Thank you all.